I understand the court cannot instruct the sheriff on how to house the defendant. I understand that. But I can't sit by and say nothing when I know that this is causing a detriment and a harm to the defendant. So solitary confinement, this isn't a new, it is not a new thing. It's ancient, it's been around for millennia, but the science on it is a couple of 100 years old. Science meaning that it's been observed and repeated, and an analysis and a rate and study of it and its effects is well documented. The harm of solitary confinement is well documented, whether we're looking at psychology or psychiatry, that this causes a very real, very measurable harm on adults. It also is, that's what's within the exhibits are examples of different branches of science, of medicine, calling for the cessation of solitary confinement. Why? Because we know it harms adults, we also know it harms children. And these studies are looking at harms that exist after 48 hours of solitary confinement. This particular child, and yes, I know he's a defendant, an adult by the court's view, but this child has been sitting in solitary in his forms cumulatively over 400 days. Now, in first instance, it was for his protection because there was concern for suicidal ideations. And then on the second instance, it was concerns of harm to others, and then threats to himself. Now, a lot of these threats are born because of the media attention to the case, so his name is well known. In Duval, this case is well known also here in St. Johns County. But there are other counties that he can be housed in. And it has been, that I've seen with my own experience, where defendants are moved for their protection. Whether they're moved within the circuit or outside the circuit, it is not uncommon for defendants to be moved, where sheriffs will trade defendants to keep that individual safe. But that option hasn't been practiced in this particular instance. What's been done is that he's been held without an ability to congregate or meet with other individuals, without eye contact with other individuals for an extensive period of time. So the worst form of solitary that's out there would be no sight, no sound, and that's not what he has. Meaning he can see other officers because it will bring him food. But it's still a form of solitary confinement. And solitary confinement, whether you're looking at psychiatry or psychology, is a form, or its results, is a harm that can only be considered a punishment. If you look at a case like Chambers v. Florida, and this is from 1940, that the technique of solitary confinement was considered at that point as a form of mental torture or physical torture the government used to coerce confessions. So it's not a debate or a question as to whether or not it's a form of torture, because it's well recognized within the law. If we're looking at United Nations, it is. Is it permissible in the state of Florida? And again, I have to say yes, it is. The case law permits it. But the issue is that we're now looking at a child that is being tortured in this form of solitary confinement. Although it is legal, he's still being tortured and punished when he hasn't been convicted. He hasn't been tried. No jury has been sworn. He hasn't even entered in a change of plea or a guilty plea and moved forward towards a sentencing. And for that reason, I'm bringing the court's attention to this and asking that consideration be made for alternative housing. Again, the court cannot tell the county jail to move him or tell the sheriff, because the separation of power is very clear. All that I can do is what I'm doing, and that's ringing the bell and sounding the alarm as to what's happening to Aiden Bucci. We've been in contact with the sheriff, St. Johns County Sheriff, and with the Duval County Sheriff on this issue. And there's been no change. Because cited the case law. I've provided the rules that they're relying on for this detention and the legality of it. But again, we can't ignore the harm of it in light of alternatives. Duval County Jail is not the only jail in the state of Florida. I am unaware as to why he was moved there, and they don't have to disclose that, being the St. Johns County Sheriff's Office. But there are other county jails he can be moved to. And that's what I'm asking for consideration, that there are juveniles held in other locations in the Seventh Circuit and beyond. So right now, he's been moved out of the Seventh Circuit into the Fourth at Duval County Jail. That's the Fourth Circuit, and we're asking for consideration of his transfer to another location that would be safe and humane. And that's not to say that the intent of the Duval or St. Johns County Jail is not his safety. It's my understanding he's there for his safety, but at the same time, this measure to protect him from other inmates is causing a harm. A harm that whichever branch of science you're looking on is well documented and well known. It is not a new thing to say that solitary confinement causes harm to an individual. But not just in the state of Florida, but in this country, in the United States, it is a very legal form of detention. It is. I cannot say it is not. I know that the response from the state is playing into, or drawing light to the separation of powers and the right to do that. But I must do something, Your Honor, and all that I can do at this point is provide these articles in support of the harm that solitary confinement causes adults, the harm that solitary confinement causes to children, and ask that some other placement be provided. That whether or not the jail will not place him outside of solitary in Duval, and clearly they have no intention to do that, that consideration be made to place him in another county where he doesn't have to sit in solitary for this extended period of time, where he hasn't been convicted. Most of the case law in favor of solitary confinement is post-conviction. There's been no conviction in this case, Your Honor. So with that in mind, I ask the court's attention to this, and I'll leave it to the state.
Thank you, counsel. Ms. Duffy, do you wish to be heard?
Your Honor, no. The state attorney's office will defer to the sheriff for the defendant's care, custody, and control.
All right, very well. Lauren?
Your Honor, I'm trying to follow the defense's position. They're essentially stating that they use the word torture, and in their version of torture, that means being kept in a facility where he's safe. I haven't heard anything, and I suppose there's an argument to be made that because he doesn't have more interaction with other inmates, maybe more rec time, that somehow that is a version of torture. I haven't heard an argument that suggests that putting him in another location or another facility would be any different, or this classification would be any different. The sheriff does agree with the defense's position on the law. In the defense's motion in numbers 12, 13, and 14, that is a correct statement of the law and the separation of powers of issue that does exist. But as far as this torturous conditions that Mr. Fucci's currently residing in, the sheriff takes issue with that. At this time, I'm going to call a witness and maybe enlighten the court as to what his actual conditions, his living conditions are in Duval County. So at this time, with the court's permission, I'll call a witness.
All right, who is your witness?
Director Tara Wiles.
All right, Ms. Wiles.
Your Honor, if we could have a brief inter, I was not aware that the sheriff was calling a witness.
That's fine. If you'd like to speak with her for a moment, I'll bring that up.
And Judge, I'm perfectly fine not calling a witness. This seems to be more of a legal argument than a factual argument. And if we want to just keep it based on the law, the sheriff's perfectly fine with that.
All right, well, why don't we just keep it at the law then? We'll take it to the law. I think we all agree on what the law is and where my hands are going to be tied to the law. So I don't necessarily know it's necessary for me to hear from any witnesses. However, I think it's us to all be working together to make sure that we're finding the least restrictive means to house him. And I'm confident that everyone is aware that that should be the priority, and I believe that that is. But I'll certainly.
Judge, I think that the responsibility of care, custody, and control is an enormous responsibility. And it's a burden on the sheriff, who is the defense rightfully suggests in our motion. He is the chief jailer of the county. The only proposal I could possibly make is if the Office of the Public Defender wants to take responsibility of Mr. Fucci's care, custody, and control, then they can have a seat at the table and they can decide where he would reside up until trial. And then at that point, we'll certainly listen to any suggestions they may have. But I'm not aware of a situation or any history where the Office of the Public Defender or any defense attorney is willing to accept that responsibility, because it is a huge burden.
Is the sheriff suggesting an RRR form, or?
No, the sheriff is suggesting that if the public defender is willing to be responsible and liable for Mr. Fucci's care, custody, and control, then they can have a seat at the table and decide where he resides up until trial. But up until that point, the law clearly states that is within the sheriff's purview.
Well, here's my ruling. Do you wish to be heard anymore? I don't think obviously that's going to be, you're going to accept that invitation.
Just for clarification,
Sure.
Meaning if the defense accepts the responsibility, he would be released? I just want to say,
I'm not sure what exactly is being proposed, but the bottom line is this: I cannot release Mr. Fucci to anyone, and I won't release him to anyone. At this point, he is going to remain in custody of the sheriff and continue to be the responsibility of the sheriff. So his care, custody, and control is going to be in the sheriff's hands. I have to deny your motion. I think you understand that, and I believe that as you've already stated, there is a clear separation of powers here, and it is the sheriff's responsibility to maintain his care, custody, and control, and I cannot order the sheriff how to go about that. However, I will reiterate that I expect that the sheriff and anyone else who's involved in this process continues to listen to your concerns, and if there are less restrictive means or some other alternatives or something that permits him additional time outside, whatever the case may be, clearly we are dealing with an individual who is still 15 at this point. I'm not even sure. 16 now. We need to all be aware that a prolonged term of solitary confinement would have an effect on anyone. So I'm going to ask that we continue to make sure that is the least restrictive thing that can be done. If there's other alternatives, I would just ask Ms. Wilds and everyone else involved. I see them shaking their heads, that they will continue to do that, and they will continue to make sure that he is properly being taken care of while in the custody of the sheriff. Ms. Peoples, I assume that you have Mr. Klein's number. I'm sure that he will be happy to receive any calls. Ms. Wilds, I know as well, would probably be responsive if there are concerns, continued concerns, let them know. We are set for trial in February, so we are getting close. So hopefully we'll have this resolved one way or the other fairly soon anyway. And we will, I know that we're going to continue to make sure that that trial date stays in February so that we can, figure out what to do next from there. Okay, but the motion is, as to that, is denied.
Thank you, Your Honor. May I approach with Council